all right, so here's what happened. So first of all, this is normal. This process is normal, and the judge's questions are normal, and there's nothing unusual about what's happening here, except, Jay Hatch's position is incredibly feeble. But it's a standard thing, right? So as I said before, you ask for a decision in your favor basically every possible step of the way. And Maya's team did too. Of course they did, right? Because the very act of filing the pleading is an act of, hey, can we get a judgment in our favor, right? That's the initial complaint is, hey, judge, you want to give us what we want, right? So, and then Jay Hatch files the motion to dismiss because it isn't supported at law. And, we argue about that for a while. And if you're Toddy without a crystal ball, we argue about it for the next year. In so many emotions and plan of pleas, it was breaking my brain. We were stuck in step one. We were stuck in step one forever. In fact, we never made it out of step one. So bad. All right. Anyways, so once you get past the motion dismissed, then typically you're in discovery. And then you have some discovery arguments about it for a while. And then at some point you have a summary judgment motion, although these guys seem to like many summary judgment motions where you're like, hey, Your Honor, we've had discovery now, and this is what plaintiffs said they thought the facts were in their initial complaint, but now we know the facts because we've done discovery, right? And in the best possible light, they didn't have the facts. They have misled you, court. They said they could prove things in their pleading, their complaint, that they can't prove. They haven't been able to produce evidence. So you should rule against them because there's no evidence to support them. They went forward on an illusion, and the illusion has been exposed through the discovery, which has not revealed what they thought it would reveal. Right? That's summary judgment. Right? And so then as a judge, you're basically like, okay, taking light of the facts most favorable to the non-moving side, because summary judgment goes both ways. Both sides can get summary judgment, obviously on different things, not on the exact same thing at the same time, but they can get summary judgment on different things. It's like taking the light in the non-moving party both ways. Then, is there sufficient facts to allow this to go to a jury? Or taking the facts in the most favorable light to the non-moving side, can a jury find this, right? And so the judge makes that call, usually once. Here, 52 times, which continues to blow my mind as completely illogical and unreasonable. So it blows my mind as completely irrational and stupid. All right. So then we finally get to trial eventually, right? And then we start actually presenting evidence. Now, the evidence we're going to present at trial is not going to be the same that we presented in discovery. And that can happen for any number of reasons, right? A witness. We're not going to call the same witnesses because we don't have the same time, right? The amount of information you uncover in discovery can be thousands, tens, hundreds, millions of pages of stuff. It can be a lot, particularly in this kind of case. It's a lot. And so you can't present all that stuff. So first of all, the stuff you're going to present at trial is necessarily going to be some slice of the information that you have available to you. And second of all, that information may not be able to be presented because insert reason, the witness has recanted or whatever, or is unavailable and blah, 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 whatever, right? So, so then we have the actual trial where the actual evidence actually happens and we actually know what they're actually arguing for real because it's really happening. Okay, great. So now we want to move at some point, and probably multiple points, at directed verdict, right? So throughout trial, we're going to ask for directed verdicts and mistrials and all that kind of shit. And basically we're like saying, hey, Your Honor, they haven't presented enough evidence. Can we win? They fucked it up. They fucked it up, and this shouldn't go to the jury. And the judge was not, I don't think during the trial, but certainly before the trial, was dismissing counts against Johns Hopkins. So he was doing that and doing some other things in relation to what would be presented. And so, hey, basically their side screwed it up. Can we win without going to a jury? And so then they consider that. And so where we are now is the very end of that road, where you have to make these arguments because you have to preserve your issue, right? You have to make the argument that we should win, so you don't waive it, right? You use it or you lose it. So this is necessary to do, and there was nothing unusual about the process as you saw it, right? This is perfectly standard. Now, of course, the issues that are being discussed are not perfectly standard, because normally we're not saying, how about a jury interview? And also juror number one is sending secret Nazi communiques, right? So that's unusual in that way. And also, it's not unusual to deal with what you got. So Johns Hopkins has the problem of the facts kind of suck for them because there's a lot of evidence against them, right? So, ideally you want to make pure legal arguments if you can. Hey, Your Honor, you screwed up the law, right? You screwed up the law. You screwed it up before. We've been trying to tell you. Would you like to reconsider now? I'd be, oh my God, I can't believe I screwed it up that hard, right? So ideally you want to make legal arguments. And if you can't do that, you want to make factual arguments, which Johns Hopkins tried to do. But the problem with that is at this stage of the proceedings, because we actually had a jury that actually sat and actually decided things, it's no longer just what the judge thinks anymore, right? It was all about, can a jury do this? But now we're talking about what a jury did. They've actually ruled, right? So Johns Hopkins' arguments basically boil down in substantive part 2. Here's a lot of reasons that the jury should have found for us. And I'm over like, well, those are good reasons perhaps the jury could have found for you, but they didn't. Right? So here's this email from Maya's mother. Here's this thing that we did. Here's this thing that we did. Probably wasn't unreasonable to do this. Probably wasn't unreasonable to do that. Blah, 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 blah. And I'm like, as a judge, even if I granted everything you're saying, Johns Hopkins, even if I granted literally all of it, I can't fix this, because the standard is essentially no reasonable jury. Put it in whatever language you like, but that's basically what it boils down to, right? No reasonable jury. Manifest weight, blah, 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 blah. But this is what we're talking about, right? It can be phrased multiple different ways, but it's essentially the same concept. No reasonable jury could find this fact, because the evidence is so overwhelming, external influence, whatever, right? No reasonable jury could find this fact. But if there's any reasonable way for the jury to find it, because the jury, of course, is the finder of fact, so they're allowed to believe witnesses or not in any degree they wish. They can believe a witness in whole, in part, or not at all. They can believe a witness is lying about something, but not necessarily everything. It's up to them. And also how much weight to give a witness is up to them. So they could simultaneously say, if they wanted, hey, this witness is lying about literally every word that comes out of their mouth, but they're just not that important of a witness, so I don't care. That would be a thing the jury can do, because the jury's the finder of fact, and it's up to them to decide how much to believe it and how much it matters. So they can choose to believe an extremely large lie doesn't matter, and an extremely small lie does, because it's up to them. It's up to them. So basically, any reasonable way that any reasonable juror could possibly weigh this in any combination is a valid choice. Anything they could do is up to them. And apparently what they did is said, Johns Hopkins sucks balls, and they should suck it. And so, Johns Hopkins is all over here like, well, here's a whole bunch of facts that help us. And I'm recorded like, what do you want me to do about it? What do you want me to do about it? It's like, so you can't win on the law because you don't have the law. As desperate as you try, because there's nothing there. And you can't win on the facts because we already had that argument. 6 people decided your fate. Eat it. So yeah. And basically if you like to view it this way, you can view as what happened just now as an appeal before the trial court, because that would also be a valid way of looking at it. Basically, it's the same thing, right? It's the same issue, basically, fundamentally. to boil it down. It's like, okay, either there's an error of law or, manifest weight or, some external influence, right? So basically you're getting a preview of the appeal, right? It's an appeal before the very same judge who heard your case in the first place, but that's okay. You are allowed to do that. You're allowed to make an appeal to the district court, and the district court is not bound by their own findings. The district court can change their mind because they're in review of themselves. And district courts do change their mind from time to time on issues as the case may be. So we've got a bit of a preview of their appeal. And based on their preview of their appeal, I'm not really seeing much hope for them at appeal. So it's not looking great because it's like, well, and also, of course, as the judge pointed out on the Court of Appeals will also point out, not only does the judge have to make a mistake, but they have to make a mistake that matters. And that's the real tricky part, right? Finding a mistake the trial judge did is easy. Easy, right? You can't sit for 9 weeks and not make a mistake. No one is that good. No one is that good, including me. I am not that good. I'd like to believe in my own conceited will that I'm that good, but the truth is no one's that good. The odds of me sitting through a 9-week trial as a judge and not making a mistake are essentially zero. So finding something the judge did wrong is easy. Finding several things the judge did wrong is easy. The next thing is the really, really tricky part. Did it matter? And probably not. So basically, it takes a pretty big F up. It takes a really big F up, right? To win this. It takes a pretty major screw up. So you don't have a lot of hope. And so then the only other thing that happened is we had the sanctions, which Judge Carroll says, well, I've been holding all these sanctions in abeyance this whole time, which, why? I don't know. And I was like, I promised you guys I'd hear the sanctions at the end of the case. Now, why you're not hearing sanctions during the case, I don't know. Like, I could understand things that happened during the trial, not doing a sanctions motion for in the middle of trial because it would disrupt the flow of the trial, unless it's like grievous. But all that stuff that happened before the trial, you should have heard that stuff long ago. And the judge is like, well, I've been holding all this in abeyance, and if you guys really, really want me to do it, I promised I would. Apparently secretly begging and hoping that they'll let it go. So I don't know what this judge's problem is, and I don't know what the problem was with the 2 judges who preceded him. Apparently they're all a bunch of pussies and don't have big judge balls. I don't know what's going on in that. I don't know what's going on in this courtroom. I don't know if it's intimidation because it's Johns Hopkins. I don't know if it's intimidation because the lawyers. I don't know if it's intimidation because they're worried about their elections or what the hell's going on. But none of them have big judge balls. You have to assume that he's not going to issue sanctions. Because why would he? Right? I mean, none of them have done it this far. So why would he do it now? And if he's going to do it now, it's going to be probably token. So he's not going to do anything substantive. Maybe he finds him like $1,000 or $5,000. So like, but he's not going to do anything major because he doesn't have big judge balls. That is the short of the hearing. That's what we heard for 3 hours. And of course, Maya's attorneys are completely correct because they have the facts and the law in their favor and the jury ruled for them. Cherry and Max says, probably dumb question, but why would a judge ask about what an interview with juror 1 would look like? That's a great question, right? So the judge wants to hear from the parties about what they think the law is, right? The judge is going to do their own research. And so the judge asked a lot of questions like, what would a murderer mean? What would it mean for me to do that? Would we have to redo this part of the trial or this part of the trial? What would that actually look like? Right? So he wants to hear about that from the parties, about what they conceive that looking like. So he can understand their perspective on the thing. Perfectly normal question. Perfectly normal thing to do. And so, yeah, asking about what would an interview look like. Okay, suppose I grant an interview. What would that actually mean? How would we actually go about it? What are the mechanics of that? And then, of course, Johns Hopkins basically didn't answer the question. They just kept talking about all the reasons you would. And, the lawyers for Maya gave an answer. It's like, well, it would be conducted by Your Honor. That's how we normally do that. And, we do it that way. So, that's their answer, right? So, and like, it's like, okay, how should I structure this judgment? Do I need to do this or do I need to do this? Does it need to be this way or does it need to be this way? The judge wants to check their own thinking. It's a perfectly normal thing to do, right? Even if you've been on the bench for a long time. Judge wants to check his thinking, make sure he's doing it right, particularly in a highly high profile case like this. The judge would be particularly well incentivized to make sure that he's, minding his P's and Q's because he knows and everyone else in the room knows appeal. So the judge wants to do his best to like avoid shit on the record. So asking the parties, hey, what does that mean? What should I do? How would I go about doing that? What does that actually mean? What are you actually asking me for? You're asking me for a remitter. Okay, what would that actually mean? Can I just do that? Does it mean I have to have a new trial? Is it just as to that part? Is it just as to the punitives? Is it to the whole thing? What does it mean? What does it mean for me to actually do that? You'll hear appellate judges do the same thing. Hey, counselor, what's your understanding of the law? If I were to decide for your favor in this way, what would that mean for situation X or situation Y? They ask counsel about what the law is all the time. It's kind of what appeal lawyers do, answering questions about the law. The appeal judges answer the questions and they also ask them. And the lawyers are there to teach. It's part of their job. They're there to teach the court. Nothing wrong with that. So the Supreme Court of the United States does it. Supreme Court of the United States, it does it all the time. Counselor, if we ruled for your favor that way, what would it mean for this situation? Or how about this situation? Or how about this situation? Or what would that look like in practice if we actually did that? What would that actually mean on the ground? How would that actually manifest itself in some way?